Hey guys, hi Kelly. I hope you are doing good. So, Cloud, Cloud Illusions, she asked, I guess it's a she. We really don't know yet, do we? Anyway, she asked what time my streams start, and I don't know the answer to that. I don't really have a time. It takes hours to get the videos, and then as soon as I get the videos, I'm excited and I start a stream. It'd be nice if I could set a schedule, huh? So I thought I would do this instead. I would just, once I get my stream together, then I'll, say I'll start in 30 minutes or an hour or whatever. Hopefully that works better. And I spent today testing the audio to make sure that my voice matches the videos. It's hard because all the courts are different, but I think everybody was in agreement that the courts were too low and I was too loud. So hopefully this goes better. Hopefully I fixed it all. I think we should start with a short one from the loudest jail, and then we'll see how the audio is. Here we go.
Leon Johnson, is that your correct name? This is case 21 MI 017150 on for return on a bench warrant for further proceedings. Case 23 MI 018878 on for return on a bench warrant for further proceedings. Public defenders appointed. You're also owed time until March 18th.
Thank you, Your Honor. Now the closing for the public defender. We are requesting that Mr. Dodson be released on his own recognizance after he serves a splash to Exodus on the 18th, and then return to court on April 11th at 8:30 in the permanent case.
Mr. Dodson, I will let you know, I normally, when you miss court after being arraigned, don't release you. I'm going to, in this particular circumstances, in light of the fact that you haven't been given an exodus opportunity, you won't be released till after March 18th at 9 a.m. to exodus. I also want to make it clear to you that if you miss your court dates, I'm not giving you another opportunity to fight this out of custody. What's the next court date?
April 11th at 8:30 in permanent please.
Your next court date is April 11th, 8:30 in permanent three, saying contact with your public defender.
Thank you, Your Honor.
Can I say something?
Sir, you just got an OR after she specifically told you she normally doesn't do that. And this judge means it when she says it. She doesn't just say that. So, of course, yes, you want to say something. This is a great idea.
Be very careful, sir. I'm granting release right now.
I understand that. I have bad of remembering things. Is there any way that my appeal can help me remember these things?
No, sir. It's going to be your responsibility. We're giving you paperwork. If you don't think you can remember it, here's what I can tell you. I can guarantee I can get you to court, sir. And that way I can guarantee I can get you to court by keeping you in custody. You got to make this a priority. You got to write it down. You got to put it somewhere. I have a bad memory. Is it going to be a justifiable excuse to the court? Are you going to make it to court?
Yes.
All right, that'll be the order.
Page 27 in custody, Hoover, right over here, sir.
I'm so sorry. I didn't know it was March. Could you hang on a second?
This is case Thomas Michael Hoover. Is that your true and correct name?
Yes, it is.
It's case 23 FB 003366. On for admit or deny a violation of probation, public defender appointed.
Thank you, Your Honor. Warren, Public Defender's Office, I'll accept appointment. Mr. Hoover would like the court to consider releasing you again. He failed to appear February 28th. He believed that the current month was January.
Oh, I'm so sorry. I have a child. I'm so sorry. Please admit that.
Sir, I'll be honest with you. I'm looking at your history of making it to court on this case. And I'm not including the VOPs, but you were placed on pretrial. You failed to appear on March 29th, 2023.
Sorry.
You failed to appear in January 10th, 2024. You also failed to appear on February 28th, 2024. So at this point, sir, you're going to have to deal with the case in custody. I'm not going to.
So sorry, ma'am.
I understand.
I'm requesting March 20th, 8:30, Department 63.
March 20th, 8:30, Department 63, sir. We'll try and see what we can do to get it dealt with at that date and time.
Okay, thank you.
Thank you.
All right, thank you.
Your Honor, regarding Mr. Johnson, can I request a med visit, please?
I'm so sorry, just doesn't cut it with her. Nope, there has to be a legal reason. You give her a legal reason, you're fine. I'm sorry is not going to cut it. That guy with a bad memory, that judge was on her more than that other guy. Remember that other guy? Do you have any kids? I don't remember. Did you finish school? I don't remember. That judge didn't care at all about that guy. Hi, Alyssa. Okay, I'm going to the next one only because I did get on YouTube. I hardly ever get on YouTube anymore to get court cases because everybody gets those. But there is this one specific judge that I love because of his voice. Hands down, the greatest judge voice ever. Nobody's been better before. Nobody will ever be better after. So I got him today.
All right, the court calls F17223 State versus Eric Clark. Mr. Clark, earlier today, after you were at the courthouse, the court sent you a waiver of counsel because you indicated that you didn't want Mr. Failer representing you. The waiver of counsel is a document that the state of Texas promulgated in 2007. Says that I have to advise you of certain matters, that you have a right to be represented by an attorney. You have the absolute right to represent yourself. There are dangers and disadvantages to self-representation, such as the fact that you haven't been to law school, you may not know the rules of evidence, procedure, things of that nature. You also have a right to hire the counsel of your choice if you are able to do so. If you're indigent and unable to afford an attorney, the court appoints one to represent you, and in fact, I've now appointed two to represent you. The range of punishment in this case, if as I recall, is 2 to 10 years in the penitentiary. However, the state has filed a Brooks notice indicating an intent to use 2 prior final felony sequential convictions, which would mean the range of punishment is 25 years to 99 years or life in the penitentiary. And so, first of all, Mr. Clark, do you intend to represent yourself in this matter, or do you wish for Mr. Failer to continue to represent you?
Represent myself.
All right.
I thought one of the enhancements got dropped off.
I am not aware of that. If so, to make it 2 to 20 years.
That's what I'm saying. It was supposed to be 2 to 20 because Greg Hill, whenever he was my attorney, said that one of the enhancements has dropped off.
I don't know. I'm not privy to that. If you have 2 sequential, it would be 25 to life. If it's 1, it's 2 to 20. And those have to be proved just like guilt or innocence have to be proved.
I've only been incarcerated in Missouri. I was never incarcerated in Arkansas. They were trying to enhance my other charge for Arkansas.
Yeah.
Your Honor, we have filed a first amended notice of enhancement paragraphs. In other words, an amended Brooks notice. It looks like there was an Arkansas one contained in their original enhancement notice. However, there are 2 sequential Missouri convictions now alleged in the enhancement notice. And so it is 2 Missouri convictions that will be used that enhances the punishment range on this third-degree felony up to 25 years to life in prison.
All right. So there's no allegation of Arkansas, Mr. Clark, but there is an allegation that you twice in sequence went to the penitentiary in Missouri. And so that's where the 25 to life comes from.
But because I've been to prison in Missouri, they can enhance it 25 to life?
Yes, sir. Doesn't matter where else it was. I've actually, that's true whether it's sex offender registration, no matter what it is, the full faith and credit clause.
How come I was offered a 10-year?
I don't know. I don't get involved in plea negotiations. What was offered before?
Can't we resolve this instead of going through all this trouble and hassle? Like, can't we plea out to something? Agree to plea out to something, Pratt?
I agreed today to lower my offer from 30 years down to the statutory minimum, which is 25. That's the lowest that a jury could give him if convicted. They can give him 25, 30, 55, 95 life, anywhere from 25 to 99 of life. And I offered to resolve that matter today for the minimum, which is 25 years. It is not an aggravated offense. And so he would be eligible after 1/4 of his sentence. And if he gets 2 for 1 good time, that would equate to 1/8 of his sentence, which is less than 4 years. It's barely over 3 years. Plus, with the time credit he already has, it would be less than 3 years before he'd be eligible for parole. That obviously doesn't mean they would grant him parole at that time or any time, because that's up to the parole board, and neither I, the defense, or the court has anything to do with that.
Can we work
But,
out something today on a 15? I would
25 is at this stage. 25 is the lowest that it would be offered.
There's no way to get under 25. Like, I'm willing to resolve this. We don't have to go to trial. We can get this taken care of. Like,
I'm willing to resolve it for that minimum of 25, but no, I'm not willing to do anything less at this stage.
That's what I'm going to get offered anyway at trial.
No, I'll be asking for significantly more, but it'll be up to the jury.
Now, the jury can start at 25. They're not limited to 25. I want to make sure you understand that, and that's why I went over the range of punishment. It starts at 25, it goes to 99 or life. That's why I want to make you fully aware of where we are today. As Mr. Pratt said, it's not an aggravating offense. In Texas, an aggravated offense requires 1/2 calendar to be served.
Well, how much time would I have to do on the 25?
You'd have to do about little over 3 years before you would be eligible for parole. I can't promise you when you would be granted parole. I have nothing to say about that. They don't ask me, and I don't have any input. That's completely up to a board called the Texas Board of Pardons and Paroles.
And then I believe he's got somewhere in the neighborhood, and you would know better than I, but somewhere in the neighborhood of 6 months worth of credit towards that sentence already.
Right.
So you'd have to do about 2 years and 10 months, and then you would be eligible for parole.
It just seems extreme for evading, though.
Well, it's all because Texas is 3 strikes and you're out law. I don't have any say so over that. So I just am trying to get this issue on this waiver of counsel resolved, Mr. Clark. And so,
all right, Brad, I guess let's just get this resolved. So I'll be able to talk to you coming up. We can resolve this.
If it's not resolved now, then I maybe would resolve it, but it wouldn't be for something as low as 25 years. So it's either.
I'm trying to get this resolved with you.
Well, Your Honor, if I could have then a moment to visit with his counsel, or if a waiver is approved with him, because I can't deal with him, that his counsel.
I've approved the waiver. I'm going to keep Mr. Thaler on as standby counsel, but he does not have to be involved in the plea negotiations. Mr. Thaler, if you want to step out for those,
well, Your
I'm
Honor,
going to step out.
Your Honor, before you do, just wanted to make sure that he's had his full Feretta, his full warnings and admonishments regarding representing himself. And if he has, that's just fine with me. I certainly
let me go over just to make 100% sure, Mr. Clark. I may have forgot to say something toward the end, actually. As I said, you got an absolute right to represent yourself. You have an absolute right to hire a lawyer or have a court-appointed lawyer. Mr. Thaler is still here as your court-appointed lawyer. If you and Mr. Pratt go into these plea negotiations and you decide you want to go back and still have a lawyer, I will keep Mr. Thaler on the case, and you will continue to have a lawyer. You can withdraw this waiver of counsel at any point, because as I said earlier, there are dangers and disadvantages to self-representation in these cases. So that's something I want to make sure that you're aware of.
I'm just trying to get this resolved. The least amount of time I can get.
All right. Well, let me let you and Mr. Pratt visit. Mr. Thaler and I are going to step out of it for the moment. And when I'm told I'm needed again, Mr. Pratt, if somebody else send just a message.
We'll notify your office. Yes.
All right. Thank you.
So just to be clear, I leave.
It doesn't matter to me, Damon, if you stay or leave, either one at all. So
Just for the sake of experience, I will shut up and stay here.
all right. All right. So, Mr. Clark, if we're going to do this, then what would happen would be I'd prepare this plea paperwork and have it sent down there to the jail for you to review and to sign. If you want an attorney to go over that with you, then I can provide a copy of that to Mr. Failer as well. And then I can, zap myself out so the two of y'all can go over it to make sure you understand everything.
You
But
said I had to
basically,
get resolved today.
that is correct. I will offer the 25 years if we're going to sign off and get the judge to approve the plea and be done with it today. Otherwise, I'm continuing to prepare for trial on Monday. This is the only case set for trial on Monday. And so I'm not going to offer something as low as 25 years if we are not getting it resolved today.
I guess I'll take the 25 today.
All right. So I'll prepare the paperwork, and that's what it'll say. It'll be the 25 years on there. When the judge goes over it with you, he'll also explain that he'll give you credit for all the time that you have, which would be from when you were originally arrested, and then you bonded out, and then we picked you up shortly thereafter. We had you in, and then you bonded out again. And so, but then you've been put back in. So you'll get credit for all of that time that you've got coming to you. All right. All right. Well, I'll fix that up right now. We'll just stay here on here because I'm not ready for the judge yet, but I've got plea paperwork here that I could put somewhere in here.
Further, is this the best you think I should do?
My guess is that
Just since you've asked me the question,
Right.
I do not think in Texas and Hill County that you can do better than 25 years on this case.
Okay.
I think that 40 and above would probably be a reasonable guess. I cannot guarantee that, but I don't think it's going to be close to 25.
I'll take the 25 as a good offer.
It's the best offer that you could possibly get.
All right. I'm gonna go ahead and take it then.
all right. And now that you've made that decision, I'll just say that I've had a couple of aiding arrests that were habitualized like this. And one got 55 and one got 65. So just so you have an idea, I wasn't going to even mention it to you before. Not that I'd be prohibited from doing it, but.
May I speak on this as well? Just to let
Certainly.
you know, though, that you're not getting screwed as bad as you possibly could have because there's no deadly weapon finding.
All right.
As Damon knows, I have done that before, and if I allege a deadly weapon, then you have to do, and the jury finds that there was a deadly weapon used, in this case, say a vehicle that was capable of causing death.
What happened to like the time whenever we like it dropped down 2 to 20 and like I was offered a 10 on that one Zoom with you? Like,
well,
I told Greg that I wanted it that time, but he wanted to pursue further evidence and some shit. And then he jumped off my case. That's why I was so mad that day. Like, I wasn't mad at you guys. It's just Greg was giving me the runaround.
Well, I think the 10-year had been withdrawn. I think there was a realization that there was an issue with the Arkansas prior because it was a probation case. Their criminal history was somewhat confusion in the way they had it written. And I think when that was realized, that offer had been withdrawn, if it ever was made. And that was prior to that hearing that we had with Mr. Hill on getting off. All right, so let me see here. Take me just a couple minutes here.
So I'll be eligible for parole in like 3 years?
Yes.
All right.
Well, let me clarify that as well. If you get good time, if you get to the prison and throw poo at people and cuss them and act a fool, you can do a lot longer.
Right. I get it.
Okay. That would be not getting good time would be automatically doubling the minimum.
I'll get all my good time here for the jail, and then I just got to have good time down there.
That's how it could become worse if you don't get the good time.
Right.
What they do here is they let the prison know how many days you've actually been in our facility here.
All right.
And then the prison makes determinations regarding good time.
All right. So I'm looking at probably, since I have what, like 7 months in already on it, I'm looking at what, I'm looking at like almost 3 years before I'm eligible for parole, like 2.5 now.
Yeah. Yeah,
Wow.
somewhere in the neighborhood of 2.5, could be, 2 years and 7 months, 8 months at the tops, something like that. Basically,
Okay.
whatever 1/8 of 25 is. 1/8 of 24 years is 3 years. You got one more year, so
It's
1/8 of that, so a
37.5
little bit
months.
over a month. Go
It's
ahead,
what?
Damon.
37.5 months is 1/8.
So I'm already got about 7 months in. So I'm looking at like 2.5
30
years. 30 more months.
Yeah.
2.5 years. All right. That ain't bad. Get this shit over with. I just want to get the shit over with. Brad, there's no way to come down that 25 at all, a little bit?
No, sir. And quite frankly, if Damon hadn't twisted my arm today, I wouldn't have come off the 30 that I've been at before. As he can tell you, my typical practice is once I get within a week of trial as I go up. And so ordinarily I would have gone to 35 at this stage, up from 30. And then I would have gone up to 40 come Friday. And then I'd either do nothing or
All right.
50, come Monday, once I got a jury that's already had to take off work and show up here. So frankly, I did it because there had been, a variety of issues. I realized that you had some stuff in another state and maybe, whatever issues there were. And I was hopeful to try to get it resolved peacefully like this. And frankly, and something that would save the taxpayers some time. I've already invested, frankly, a fair bit more amount of time because I had this file at home this weekend as well. But in any event, that's kind of where we're at. Let me make sure I've got everything on this list here. I have to check off video recording.
Poor lawyer working on a weekend. My heart breaks.
Huh? No.
I'm about to sign it and date it.
All right.
And then what we're going to do is one of my secretaries will scan this document into the computer and they will email it down to the jail there. They'll print it out. So you'll have an actual hard copy in front of you for you to go over. And then once you sign that, they'll email it back to the judge so that he'll have it in front of him when we go through the procedure.
When will it be finalized?
Here in the next, well, we're going to send it to you. You'll sign it. Send it back to the judge. He'll come back on. We'll go over it, and once we're done all that, then it'll be finalized right then and there.
All right.
So it'll be finalized here this afternoon.
Okay.
Here hopefully in the next 20 minutes or something. Basically, the longest part is going to be for them to print it out and bring it to you, and you to go over it and sign it.
All right.
Because the judge, he's familiar with them, obviously, because he's done thousands of them. And so he'll get it back and then he's going to go over it with you to make sure that you've understood what it is that you've signed, which will be stating that I'm pleading guilty to the offense of evading arrest with a vehicle, that I'm pleading true to the 2 prior Missouri enhancements set out in that notice of enhancement. And then that you are entering a plea of guilty voluntarily, and that you're waiving your right to appeal. In other words, you can't change your mind next week and go, you know what, I want to appeal it. You can still, I guess, attempt to appeal it, but basically you will have in this document waived your rights to appeal. And so, your attorney or somebody else can advise you on that. I can't give you legal advice regarding that, but basically you're going to have waived your right to appeal. And so it'll be finalized, in other words.
And there's two layers of that, because you've also, for accepting something less than the maximum in this case and by law, that on a plea bargain, that is also a waiver of appeal.
And like I say, if you want, you can go forward with it where you're doing it on your own, or you can go forward with it where Mr. Failer is your attorney advising you regarding those things. And I can get off this screen and have them take me out, where if you got something that you want to ask him, you can. I don't care. Or I can get up and walk out of the room if you got something you want to ask him without me in here, or I can have them turn me off. Whatever you
I'll
want.
be happy to help either way. Whatever you want to do, you're in charge. I'm here as a resource.
I was just trying to make sure, like, this is legit, like the best offer I'm gonna get.
It is.
It is.
I'm a man of my word.
It just seems so extreme, Pratt. Like, why I'm getting so much time for evading? Like, I wasn't even trying to evade that night. Like,
some people certainly do feel that way about the way that it is in Texas, because not every state by any means is like that, and frankly, perhaps not even every county in Texas would do something similarly. But it is the state law, and that's what we do here. And frankly, the juries here in Hill County, understand that part of the law, and they would do whatever's appropriate. And punishment, you'd be able to bring up whatever you wanted to. I would be bringing up things like the fact that you have 11 prior felony convictions in Missouri, plus that you got pen time on, plus a couple in Arkansas. So this is your 14th felony, not just your third strike, or even your fourth or fifth or sixth. It's your 14th. And so, a jury would do whatever they think is appropriate in that case. And it certainly could be much more than 25.
I guess here's the paperwork.
Well, that's quicker than I expected.
Yeah, that's magic.
It's me, Matt. All right. You're going to sign right there where it says defendant signature?
They want me out of here quick.
And take make sure, don't sign anything before you feel comfortable with it. And if you've got any questions, feel free to ask Mr. Failer. And again, if you need me to step out or something, I'll be happy to do so. Otherwise, I'm happy to stay in here and visit with you guys.
I'm trusting you for this fucking taking this plea deal, man.
All right, so you're going to sign there.
I'm just trying to get this shit done. I want to go home to my family.
Fair enough.
And you are a citizen of the United States.
Yes.
Right there. And right there. Okay. Then you're going to sign right there. You're going to sign right there. And then you just sign right there and put a good address and phone number if you have one. Do you have a phone number you want to put down?
No.
That's fine. Okay. All right. I'll get these right over, Matt.
All right, I signed him, Matt.
Well, actually, you were right probably before when you said my name, and she was wrong. It's Mark.
Oh, man, yeah, Mark. I'm sorry.
Yeah, no, she said
I'm sorry,
that.
I'm sorry,
She misspoke. There's a judge up here in a different court named Matt, and that's probably what she got confused with.
All right, so this is over with now?
Well, not yet. The judge has got to come in and then and approve it. But she's about to email that to him, and so I'll have my office let him know to expect that to be coming now. I'll go tell them to call down to his office.
25 years, dude. So further, this is honestly the best that I'll be able to get, you said?
I would think at jury, you're not going to get less than 40.
Which
So
they
then I would have to
explained.
do how long? That's even more, a lot more in.
Yeah.
So, all right.
And so
I just, all right, that's fine.
All right, the voice is coming
If
back.
y'all are talking and need me to step out,
No,
just let me know.
no, you're good.
All right, well.
Just can't believe I'm getting that many years for an evading charge. Like,
Well, it may not seem like a bright side, but on the bright side, it's anywhere from 25 to 99 or life, and it's often explained to a jury the middle point of that is 62 and a half years. And you're getting the very minimum that by law a jury could give you if they found you guilty and found those enhancement paragraphs to be true. And I have certified copies of those judgments as well as your fingerprints from Missouri and an expert to testify that's that to prove up those priors of yours. And so if they do find you guilty of that and those enhancements, that's the least they could possibly give you. And so basically be like you had a jury and then won out and got them to give you the very best possible sentence under the law. So I know it doesn't seem that great, but like,
but I mean,
yeah.
all my offers were a lot lower than this before.
Well, I'm not sure what all, my assistants had previously offered on this case. One of them was handling it. I took this case because there was a sex case that was going to go to trial. And so I took this one to go to trial in case that other one fell through, which it did, which is how we got back up here. And also there was an issue in looking at it with that Arkansas prior. And if you had only had one prior conviction, then instead of it being a 2 to 10 range, it would have been 2 to 20. So you could have gotten anywhere. So you could have got, so 10 would have been the middle range of 2 to 20. Right now, your middle range is 62.
2 to 20.
Well, if it was 2 to 20 range, then yes, 10 would have been in the middle. Right now, because you've got the two sequential Missouri ones,
What does that mean, the two sequential Missouri ones?
The sequential means that you commit an offense and you get convicted, and then you committed another offense and get convicted. In Missouri, you had a variety of offenses with different offense dates. And you had...
I've been to prison in Missouri multiple times.
Yes.
So that makes it down here 25 to life?
Yes, sir.
That's crazy.
It is pretty wild. Really, just any two sequential ones make it 25 to life. And you had, between 2009 and 2013, you had 11. You got sentences of 5, 5, 5, 5, 4, 5, 3, 5, 5, 7, and 2. And then you got one in 2020 that you got 5 on. You had the 2 felonies in Arkansas, but you didn't go to prison on either one of those. I think in the original enhancement notice that the judge was talking about, the Brooks notice, it had alleged one of those Arkansas ones, which they mistakenly thought was. That's why they filed an amended notice showing that the sequential Missouri ones had made it 25 to life. And so, like I say, here, you're way past that minimum of 2 sequential. And as you mentioned, you've got a number of them there.
Yes, this don't make any sense. I've never been hammered so hard over something so petty in my life.
Texas is
I won't be back to Texas. Sure. Will not be back to Texas.
I hear Washington is nice.
I expect we'll see the judge any moment now. I talked to my secretary, and she was going to call down to his secretary and let him know that
What all else are we waiting on?
Well, once you sign those papers, that lady was going to take them back to a scanning machine and scan them in and email them to the judge. But you saw how quick it got down to you, so hopefully it'll get back up to them that quick. And if so, then he just is going to print it out and come back in here and sit down, and then he's going to go over it with us.
Can I time you use the restroom real quick?
I don't know.
I got a piss bad.
I can't tell. Obviously it's up to the folks down there, but
I'm gonna see if I can go use the restroom real quick. I'll be right back.
You think we got 2-3 minutes?
Yeah, we got 2.
Yes, sir, I do, and I'll let the judge know that I said it was all right.
Mark, have you seen that having to pee is actually more dangerous than being, oh, no, I saw a thing that having to pee when you're driving can be more dangerous than being drunk.
I'm sorry, Angie was talking to me, Damon. She was telling me that the jail had sent it to the wrong email address, but they did send a copy to us, and so she's now forwarded it to the judge's office. Good. That's what the delay was.
Okay.
And we'll see if that mistake has given him so much time that he's now going to change his mind. But
no, I don't think so.
I didn't want to let him go, but I wasn't going to make him pee himself either. So I don't know. We'll see what happens there.
I think it's.
Here comes the judge.
Well, it's the best outcome for him. Your Honor, he needed to go to the restroom.
Okay.
I told him it was fine.
Yeah, no, I'm fine. I just did the same thing myself. So.
I think they accidentally sent the documents to just back to my office, but Angie got a copy of that, fortunately, because I don't know that I would check for a while, and she forwarded it on to your office.
Oh, perfect. I didn't know what happened with them, but
so
that's fine.
My understanding is he's doing this plea at this stage pro se.
Yes.
Is that right? All right.
Yes. Yes, I had approved the prior.
All right. Now, obviously, I don't have a copy of that, but my understanding is that when I heard you say you approved it, that you've approved and signed it. And so.
Yes, sir.
All right. I'm going to pull up a copy of those documents just to see if he signed everything.
He did. I've been through him.
All right. Thank you.
All right, Mr. Clark, I finally got those papers, so I will proceed to F-17223, State versus Eric Clark. Mr. Clark, my understanding is you and the state have reached a plea agreement for that minimum of 25 years. Keep in mind that is the minimum. When the court accepts it, there will be no, and I am going to accept it, there will be no right to appeal. You've proceeded today at this stage without an attorney based on that prior waiver of attorney that you signed earlier and that you told me you wanted to go forward on. And is that what you still want to do?
Yes, sir.
You've told me that you're guilty, that the two priors are in fact true, that you'd be sentenced to the 25 years and you would get credit for any and all the back time you've got coming. Is that your plea agreement, sir?
Yes, sir.
And of course, basically that means we're done here today. Mr. Pratt, does the state have any evidence it wishes to offer?
Yes, Your Honor. The state offers as State's Exhibit 1 the plea admonishment documents that the defendant has just signed, which contain a written judicial confession.
All right, that's admitted. Then Eric Clark, based upon your plea of guilty, true to the two enhancements and to the introduction of States 1, the court does in fact find you guilty, finds the enhancements are true. Based upon our conversations, of course, I believe that you are in fact competent, and based upon your waiver of counsel, I find that was freely and voluntarily done. You'll get credit for all the time you've got coming. They'll bring you up here probably this Friday to sign the judgment. Look at it because it'll have your day's credit on it. If you don't think they're right, you let me know so that I can take a look at it as well. All right, sir?
All right, thank you.
Thank you. We're in recess.
Thank you. Good luck to you now.
All right. Good
All
luck.
right, thank you, Pratt.
Yes, sir.
If y'all
Thank you,
can,
Mr. Pratt,
if y'all can send Mr. Pennington in, please. Yes, he's through. If y'all can send Mr. Pennington in, please.
yes, sir.
Man, I would die to see a subset go in front of this judge or a Karen. or somebody that makes him raise his voice. Because he's scary enough now. Terrifying voice. He should be reading horror novels. Because that would just be horrible. All right. Oh, this one's great. Let's go to this one. We're going back to California.
Relva? Yes. Okay, 39 through 47, Relva, in custody present? Yes. Stephanie Ray Relva, is that your true correct name?
Yes, thanks.
You have 9 cases in front of you. Case 21 MI 007597 and case 22 MI 000288 are on for benchmark for further proceedings. Then you have case 21 MI 014567 on offense date April 23rd, 2023. Count 1, alleged trespass on land without granted permission in violation of 602K. Count 2, trespass on private property in violation of Sacramento City Code Ordinance 9.080.010B. In case 23, MI 01192. 2, offense date May 15th, 2023. Those same 2 counts of trespass are alleged. Case 23, MI 012589. Offense date May 22nd, 2023. Those same 2 counts of trespass are alleged. Case 23, MI 012649. Offense date May 28th, 2023. Those same 2 counts of trespass are alleged. Case 23, MI 018394. Offense date August 21st, 2023. Those same 2 counts of trespass are alleged. In case 24 MI 001497. Offense date November 5th, 2023.
Anybody want to guess what these charges are?
Those same 2 counts of trespass are alleged.
Yep.
And finally, case 24 MI 003868. Offense date December 22nd, 2023. Those same counts of trespass are alleged. As to all 9 cases, the public defender is appointed.
Thank you, Your Honor. Stacey Jackson accepting the appointment. If I can have just a moment.
So while they talk, I'm going to give the prosecutor excellent legal advice. I'm going to give the prosecutor legal advice. If the prosecutor just tells this woman she's not welcome in the jail at all anymore, this woman will spend the rest of her life there. She'll trespass every day. Thank you, Mr. Waldo. Appreciate it.
Just to be clear, Your Honor, the court's not willing to release Ms. Relva.
No, too many cases.
Ms. Galata, Ms. Brennan is on these cases, and the other day we had discussed her trying to work out a 4 assessment offer. Are you able to let her know that Ms. Relva is interested in being assessed for the 4 program?
I can send an email.
Thank you so much. And if we can come back on all of these cases, March 21st, 8:30, 63.
All 9 cases will be continued to March 21st, 8:30, Department 63. That'll be the order.
Man, I wish I could get Department 63, but I can't. They don't live stream. All right, we're going to stay in California for one more before we move on.
Page 5 in custody, Mario. Jonathan Mario, is that your true correct name?
No, I mean, no, yes, ma'am.
You have two cases in front of me, sir. Case 23 MI 007228. Offense date October 26, 2022. Count 1 alleges a petty theft in violation of Penal Code 484. You also have case 24 FE 004401. Offense date March 12, 2024. Count 1 alleges resisting an executive officer in violation of PC 69. You also have a warrant for sales out of Placer County. Counselor, are you retained?
I am, Your Honor. I've been retained into the process of being generally retained in this matter, and is prepared to ask for Mr. Bellarmino's release at this time.
Can you state your name for the record?
Matthew Taylor, on behalf of Mr. Bellarmino. Matthew Taylor.
Are you asking for OR or are you asking for?
I'm asking for OR, Mr. Bellarmino, on the matters that are in Sacramento County, the petty theft matter from 2023 and the PC 69 from 2024 that occurred on March 12th. Mr. Bellarmino was given a pretrial release level of 1. He's going to ask for the OR on those matters at this time.
One moment, and then I'll hear from you, Mr. Lott. I'm just going to read the PSN.
He's a retained lawyer. So this guy should have an easy day, right?
Go ahead, Ms. Lotta.
Thank you. The people are objecting based on the conduct in this case, but also that I'm concerned he's a flight risk. He has a warrant out of Placer County, I believe, for I believe it was 11379, the PSA indicated. And then he had the warrant here in Sacramento for the 484 misdemeanor. He now has another case here, the 24 FE case. In that case, there's a traffic stop. The defendant immediately flees on foot when contacted by law enforcement. He pushes officers, shoves them, resists arrests, ignores their commands, and essentially fights with the officers. Again, I am concerned based on the conduct of this case, but most concerning is the flight risk. He attempted to flee from officers. He has warrants that were issued here in Sacramento County on that 23 MI case, and then a warrant in Placer County as well.
So, counsel, I'm going to kind of go through what I'm thinking so that you can respond to this. There's a couple of concerns that I have here. While I understand that the defendant is level 1, here's what I have a situation of. I have a situation when officers try to contact your defendant. It's not just a typical sort of, he very much tried to escape and flee from the officers in this case, which causes the court concern of his return. Then you add to it the fact that he has a no bail warrant out of Placer County for sales, which thereby further exacerbates the court's concern that he's not going to return to court. Then I have the fact that he had a warrant from 2023 from a case that stemmed from October of 2022. I don't know how long that warrant, it sounds like it was in arrest warrant status for a period of time. So I'm not necessarily going to hold that warrant completely against your client, but my concern is when officers tried to arrest him on that warrant, what happens here? And he doesn't leave me with the feelings that he's going to return. And I think it would probably behoove him to deal with his matters here and then deal with his matters in Placer.
Potentially, Your Honor. Just as it pertains to the 11379, that occurred in 2016. It looks like that is in regard to some sort of violation of probation. There's been no police contacts between 2016 and the police contact that apparently occurred in this 484 case. There wasn't an arrest as it pertains to that 484. It doesn't appear on his rap sheet. It looks like that was a notice to appear. And that could be explained away by the fact that they got lost in the mail and didn't know about that court date. As it pertains to the PC 69, I would just point out, in regard to Mr. Bellarmino's history, he was gainfully employed. He just gained a new job with Canvas Cultivation as a maintenance tech. It's new employment. It's employment that he's been seeking for a long period of time. He has a 17-year-old daughter who partially relies on him for financial support. He has a grandmother who's 77 years old, who also relies on him for physical support. As it relates to the Sacramento case, I'm asking the court OR in the case. Placer County can determine what it's going to do regarding the 11379. In all likelihood, based on the age of it, he'll be given a notice to appear. He has, go ahead.
Mike, I wouldn't OR him normally on this felony. I'm just gonna be clear with you about that. I would probably have considered pretrial release for this individual, except he's not eligible for pretrial release because he has a warrant out of another county. So I can't give him pretrial release. I would have felt far more comfortable releasing him on conditions that he had to check in. I can't do that in this circumstance because of the warrant. If the warrant gets taken care of, he can certainly come back and ask to be placed on pretrial release. Based on his behavior, based on the charges that were filed in this case, straight up OR, I don't feel confident that he'd come into court. If I could place him under conditions, I would, but I can't in this circumstance because of that warrant. So my choices are release him on OR or keep him in custody. And those are my only two choices. I don't have a third option. If I had a third option, I would take that option, but I don't have that in front of me. And so that's the difficulty that I'm finding. If we can figure out a way to make that happen, I'm happy to re-review it and go from there. But with the behavior here, I think conditions would be something I would want to have it in place rather than just straight OR.
Understood. I'm asking him to come back March 19th to see if there's an offer from people and to see if we can resolve the matters and hopefully resolve the matter in classroom.
March 19th, 8:30. Zach, what's it going to be? Is it the felony dictates, correct?
Yes, Your Honor. It was
61. So 8:30, Department 61. That'll be the order. Thank you, Counsel.
Make it quick, Counsel.
I can't get Department 61 either because they don't stream, but she's not telling him he has to take care of the other case completely. She's just saying he has to take care of the warrant. So, he has to just get in front of a judge and pray that that other judge will give him an OR or something, or some bail that he can just take care of that warrant. Then he can come back in front of her. There's no way she's going to give him an OR. Even if he didn't have that other warrant, I can't see her giving him an OR. Not with all that he's done. Okay. So those are the court cases I have. Now I have another one. It's 24 minutes long, and it's more an interesting legal argument. I thought it was really great. Nothing crazy, nothing funny happens here, but if you're not interested in seeing a very interesting legal argument, then you might want to dip now. Go make some cookies or something. Oh, it's St. Patrick's Day. Go eat some bangers and mash. Oh man, I've had so much of that this week. I can't eat any more of that. Oh, Waldo, go to work. Thank you so much. I hope you have a good day at work. All right, here we go. We're going to... Oh, sugar. I don't know which state this is. Maybe we'll figure it out. I want to say Colorado. Well, could be Indiana. You guys will tell me. There should be a flag, right? No flag.
Right.
It's Zoom. So it's
22 CM 564, 20 CM 2824. There was a motion to dismiss the petition of probation.
Right.
And the court had issued an order. Magistrate Court needed an order February 21st, 2024. Said court will entertain arguments of both parties at hearings set for today. So to that, to a motion, your arguments.
Thank you, Your Honor, Mr. Ivory had multiple PPRs filed because he had probation in his CI cases and in felonies. But my concern or my particular issue is that the line of cases that the state seems to rely on, or the court seems to rely on, for the idea that someone could be violated at any point of probation, even when successive probation hadn't started, is basically Ashford v. State and everything, which Ashford v. State was a
case of first impression, the court looked at all those neighboring states and said, well, yeah, someone can still be violated even if they're on a probationary period. The big concern I have with these cases, big objection I have with these cases, is that all of this discussion involved the question of whether or not someone could be violated for probation if they were not in the probation phase of a sentence, a single individual sentence. So the question was, okay, they're still serving time, can they be violated for probation, or they haven't yet started probation or done serving their time, can they be violated for an offense during the course of the sentence, and that's still be a probation violation. Here we have the issue of Mr. Ivory's cases were specifically ordered in successive sentencing, which means the sentence in question that they're violating on had not been started in any way, shape, or form. It's not just that it wasn't yet completed, it's that technically the sentence had not even started. And the violation, they're basically saying, here's a violation during the sentence that's active, which is the felony case, because they've already done the violation. Now that we've done that, we also want to say that the same violation applies to sentences that have not even started. And it's not a matter of they were current sentences, this is a matter of the express language of the sentencing orders makes them consecutive sentences. So there's no way, shape, or form where you can say that these sentences have started, and since they're at any point in their sentence, therefore a violation is permissible. This is the question of, can you violate something that technically does not even exist yet? Has not been ordered to start at this date yet. And my argument is that if you're saying that, well, we have this authority and basing it on that, but that's not really what the actual case or any of that line says. The entire line of cases basically says, at what point during a singular sentence could we say someone's in violation of the probation phase of that sentence? This is a question of the back-to-back sentences where they're saying, well, a violation during sentence A must therefore apply to sentences which have not even started. Okay. And that's not what the case law says. I mean, I get that how courts have treated, but there's no real treatment in recent years where anyone said, hey, wait a second, this is a problem. Because everyone's gone on this assumption that, oh, okay, well, Ashford says we can violate a sentence at any point. That's not what Ashford said. Ashford said, during this one single sentence we're looking at, can we violate it at any point during this singular sentence? And that was the case first impression in Indiana. And it didn't say, okay, we have multiple sentences that someone is going to be violated on. It said we have just one sentence. And if the language were muddy, if it were a question of someone was sentenced and it was just, oh, they have multiple sentences, that might be an argument I could see the state could succeed on when we said, well, it's possible you could argue the CM case effectively started the sentence running. But in this case, the language in the sentencing orders makes it clear that these CM sentences must be consecutive to the completion of the felony sentence, which was still running when the probation violation occurred. Therefore, you can't say that these CM sentences had even started for there to be a point when they could be violated. And if you're going to make the argument that, well, Indiana lets you violate sentences that have not been technically started, then at that point, that should be a new case of first impression for the Supreme Court to take up, because that's not what they ruled now. What they ruled was.
When you say a new case of first impression, so yeah, there's a case law that's
no, but there's, well, what I'm saying is there's no case law that supports the way the practice has been wrong. They took the case where the Supreme Court said, we have a case of first impression as to whether or not we can violate probation before the probationary phase of a singular sentence. And everyone's looking around and said, oh, we can violate probation whenever. Now, there was a line of cases, but each of those line of cases, you know, when I told them, they all were people with singular sentences. Courts have just been saying, oh, well, you know, these cases let us say we can violate their main phase of a singular sentence, but there's nothing in any of these cases that says, what about a sentence that has
too long didn't read version, real quick, in case you can't understand this mumbo jumbo, is that this guy committed 2 crimes, was pled guilty or found guilty in a trial or whatever, was guilty of 2 crimes, and he got 2 sentences. They are concurrent. So he has to serve the one on probation, and then as soon as that's over, then he has to start his next one on probation. Well, he's still in the first one. He's still in that probation of the first one. Second one hasn't started yet, and he broke the law. And they extended both probations, the first one and the second one. And this lawyer is saying, you can't do that. You can't extend the second probation because he's not on probation yet for that. His sentence didn't start. You can extend it on the first one, but not the second one.
It's not yet started. Because it's not a question of, we found out about a violation a year after a sentence was complete. This is a case where they're basically saying, The violation occurred a year or possibly even longer because these are supposed to be consecutive before the sentence even started. Can you say someone's in violation of the sentence that they have not even begun to serve? And at that point, my argument would be that Ashton says nothing about that, and there's nothing in the case law to support that. It's just that that's what probabilities have been doing. Now, they've been doing that on the basis that when there's violation, the probation department says, okay, well, he's got all these sentences currently out there, we're just going to violate them all. But when you look at the actual sentencing orders, there is a distinct difference between concurrent sentencing, where that would make sense, and consecutive sentencing, where the court is specifically ordering this sentence does not start until the other sentence is entirely completed. And if you're going to say that there should be a probation violation at that point, then the argument would be that if you successfully complete one sentence, let's say you've got a felony, 2 F3s back to back. So you've got one sentence that ran for 3-4 years on probation, he completed it. He's into his other sentence, and you say, oh, he's got a violation at the end of the second sentence. Therefore, we're going to look back 6 years for the first one. You've already signed off, successfully completed, and is outside the look back period for saying it's a violation. And that's not what's done, but that's what the argument would seem to imply is that, well, we could violate someone on probation at any point. It doesn't matter when they complete their sentence. As long as they've been on probation and been on probation again, that any of the probationary periods at any point should be violated, should be subject to violation, which is not how it's treated in retrospect. But they're making the argument that they should treat it going forward.
Well, isn't that no? Because there is specific language in the statute provides for a time frame for, as I said, the look back. But within the period of probation on the one that
and that's my argument. There's statutory limit to look back. For the case of violating forward, they look at the case of first impression because they didn't have the statutory language, and no one ever said, well, let's develop statutory language. And in the case of
what does the statutory language talk about with reference to money petition or probation to be filed?
It's the probation revoke will be filable up to a year after for violation of the current during, but during the course of the sentence. That's what
does the language say it has to be during the course of the sentence?
I don't have the actual statutory side of the court cases, but I don't have the actual statutory side. But the actual case that supports all of this, the language that was completed serving his sentence, that you were able to violate someone at any point while he was serving his sentence. That's the language I will actually problem is that, again, in this case, when you're saying there's a consecutive sentence that cannot start until the other is completed, then you can't argue that someone is still serving a sentence or was serving a sentence at the time of the violation, because according to the court orders, the sentence could not have been served at that time, could not have possibly started. That's what the consecutive sentencing is. So, I mean, they're relying on the idea that technically he's serving this extended period of probation. And in the aggregate, sure, if you say someone's on probation back to back to back, you could say, well, he's going to be on probation for 10, 15 years. But the individual court orders that dictate what each actual sentence is, when they very clearly say this is a consecutive sentence that must start after the other sentence is complete, that is a clear breakdown that the probation department needs to respect. They can't be saying, well, technically he's on probation for this offense in this case, if he's not, because if the probation department is going to sit there and basically say that, well, someone could violate probation during this time period, then arguably they're violating the court order on the sentencing because they're treating the probation sentences as they've already started in sentences which are supposed to be consecutive. You know, if the probation department says, well, this person's sentenced to our department, our monitoring of the felony and then these 2 misdemeanors, we're going to treat everything as being all at once. We're not going to even make credit on this. We're going to assume that there'll be certain misdemeanors starting today. But that's a violation of the court's order. The court order specifically says the sentence is consecutive. It does not start until the felony one is done. But that's how they treat the probation violations.
Anything else, Mr. Black?
No, and I mean, I know it's basically almost an argument of first impression, but you know, when I see these consecutive probation cases, and I see the argument that, well, that's what case law says, the problem is that's not what the case law says. All these sentences of case law refer to singular sentences, where they're wondering about what phase during a singular sentence or during concurrent sentences the violation occurred. They're not addressing a situation where the court order has specifically said this sentence must terminate before the other sentence can start.
Mr. Russell?
Statement cited actually is by Mr. Black, looking up that I would argue that the language there is clear on whether probation can be revoked before it is argues it can be done, quote unquote. But it also sanctions the court party versus state, Indiana Court of Appeals, to give you your honor the statement.
What's the site?
975 Northeast 2nd, 833. There, the Court of Appeals specifically deals with this issue as the petitioner there was contending that the court could not revoke his probation where it had not even begun. The court cites actually also cites a case, Rosa versus State, 832 Northeast 2nd, 1119. The court specifically notes that the probation can be revoked before, again, quote unquote, has even started. Again, citing those cases, noting that even if the sentences are ordered to be consecutive, they can still be revoked pursuant probation would be revoked pursuant to 3538-2-3H. I would argue that the Indiana Supreme Court of Appeals has been very clear, Your Honor, that probation can be revoked even where it is successive like this. I believe that the court should follow this precedent set by the Indiana Court of Appeals and the Indiana Supreme Court. I would also note it would seem, frankly, a bit nonsensical to say that someone is on probation for multiple cases, even if they are ordered consecutive. The timing of those sentences might run back to back, but as a practical matter, if someone is technically on probation, it would be nonsensical that they could be violated on that probation. They're still under the supervision of the courts.
I mean, I'm not saying that they can't be violated on probation. My specific issue is the probation they're violated, the sentence they're serving at the time of the probation violation. It's not that he cannot be violated on probation. It's the violation needs to fit the time frame. So if it's an ongoing offense, or if it's a new offense, well, he's pending sentencing. It would depend on the offense and depend on the sentencing curve, but it would also depend on how the violation is treated. And in this case, it's not that he's not being subject to any violation. He has already been subject to violation on the felony sentence. To say that he's then subject to the subsequent sentences, which haven't even started, it's basically, I mean, technically it's sentencing and not conviction, so you can't say double jeopardy, but it's effectively the same circumstance where you're saying that the one singular offense is going to be used to punish and punish and punish again outside of the strictures of what the sentencing order would say, simply because technically he's going to be under that supervision continuously. But the flip side of that is that, let's say one of those cases went up on appeal and was overturned. Would you then say, oh, well, technically he's still continuously on supervision, so it doesn't matter that these probation in this case was appealed or the sentence on this was overturned, he was still technically on probation because it was a continuous thing. There has to be a law. If he took all three up on appeal, two of them were the one misdemeanor that said consecutive to the felony was overturned, then would you say, okay, well, technically he would no longer have been on probation beyond a certain limit? Or would you say, no, it doesn't matter, it's all continuous, we're still going to violate it? And I just, the better way to explain that is if he does 5 years on probation, and at some point, one sentence is a year in between, like 3-1-1, so one right after the 3-year term, if that's overturned, would you then say, well, if you violate probation in the 5th year, then technically he's still subject to the violation of probation? Or would you have to acknowledge that, well, if that one sentence is overturned, then technically his probation is cut short at year 4, and it doesn't matter what you did in the 5th year, retroactive. But what they're saying with these violations is that a violation at any point, in any one of these sentences, continues to be a violation of laws probation. And that's a problem as a principle because let's say he's convicted of something and he gets further continuous probation. If that conviction constitutes a violation of the prior probation terms, why does it automatically constitute a violation of the new probation term? Because under the way that the state's arguing it, you can't really form a part time when one term starts and one term ends.
Well,
it's a violation.
You're saying that if someone gets convicted of offense and put on probation, if that's a violation of the previous probation, how can that not be a violation of the probation?
Exactly.
That doesn't make any sense.
Well, that's what I'm saying.
That's the argument.
Well, the argument is that if he's getting these violations for a given time period. You know, with the look back period, you're saying that, okay, someone violated at some point, and it's a look back period in the past year. And then you're saying that the Supreme Court says he can be violating probation, but I'm not saying that's not what the Supreme Court says. But when they cite to the earlier case, what they're citing to is not a case that actually says that. When they use this language, the actual language from the case they're citing to says it's during one term, a singular term sentence. And the question in that case was, can he be violated for probation for the probationary period of a single sentence has started?
But doesn't Rosa specifically deal with the consecutive sentencing?
Yeah, but they deal with it on the basis of relying on the earlier cases.
But how does that nullify the Court of Appeals decision saying that it applies in that circumstance?
Because the Court of Appeals basically says, well, we think you can violate probation at any point.
Because
based on this earlier decision.
That is statutory construction. The statutory language, and you didn't have the language that I do. Indiana Code 3538(2)(3). If the court finds that's now it's subsection H, right, and subsection F. If the court finds that the person has violated a condition at any time before termination of the period.
Right.
But
the question is not the any time. The question is, what is the period? And in this case, it's not a question of we're not sure when it ends. There's a very clear right line in these sentences that the period is terminated and then the next sentence starts.
So I'm going to borrow from Rosa. So your argument is that if defendant is on probation for 5 years and has a consecutive period of sentencing of another 5 years on probation, that the defendant can commit 17 million crimes, how many crimes he wants to commit, and that has no bearing in any way, shape, or form on the second part of probation.
It shouldn't affect the second probationary term to the point where it's, the way I would say it is, if there's no consequence during the first period, then maybe you could argue that, okay, well, there has to be some level of punishment here, but
so only if there's no consequence during the first period, do we now relate it to the second period? So you are arguing double jeopardy, even though you said you weren't arguing double jeopardy. Okay. You're going in a bunch of different ways, all to try to make it the same apple, and
pretty much.
And it really, and while I don't find your argument to be in congruence with the very clear case law and the way the case law. If ASHBA were anything, ASHBA and its progeny were anything other than ASHBA deals with not with these specific types of cases, but with the idea of statutory interpretation. And the question of what does at any point before the termination of the probation period mean?
Well,
and how does that apply?
That's really
Get him, Judge. Get him.
That's my concern with it is that on the first impression analysis, they're basically looking at what does the period mean, and their determination of what the period means is any time during that sentence. It didn't contemplate back to back. And their concern was, okay, the period is, you're sentenced 365 days, you're not concerned with probation, fine. Anytime during that 365-day period. But when the court orders sentences that must be consecutive, those are clearly separated periods. Because if they weren't, the order wouldn't have to specify consecutive. If, for instance, the court simply ordered, well, I sentence in this misdemeanor or this felony, and probation department is free to treat them however they want in terms of timing. You could make the argument that it's muddy and it's one giant period. But when the court order specifies that this must be served consecutive to a prior sentence, then the court has told probation department, this is the period, it's right here, this is the next period. And I think that's the suggestion. I would say that's the decision from Rosa, is that when you have the clear language, it's difficult to say that this is all one giant period of time for sentencing because the clear language doesn't leave that discretion to the probation department. If there was some discretion there where they could say, well, technically we're going to say he was running misdemeanor for 6 months, or as long as we get all the months, it's fine. We don't care. We're not going to be that detailed, maybe. But when a sentencing order specifies when a sentence must start and when it must end before the next sentence can start, I would say there's no discretion for the probation department to be able to say, well, we're treating this as one giant period, because the court has said, no, these are clearly separate. We are making them separate. And that's why, like I said, why I didn't say Rosa, because it's not a matter of a blob of sentencing. In this case, there are discrete sentencing periods. Now, they might be served continuously back to back to back, but they're still discrete by court order.
Mr. Black, while I understand,
Yeah.
while I understand your argument, and I appreciate the passion with which you've made the argument, I believe that I am bound by the Supreme Court of Appeals precedent, specifically in relation to Ashcroft 570-937, Court of Appeals from 1991. State cited Ashley v. State, which is 717, which is cited 927, Court of Appeals from 1999. That case specifically holds that the probationary period begins immediately after sentencing and ends at the conclusion of the probationary period with the final sentence. That was applied in Rosa v. State, 32 November 2nd, 2019, Court of Appeals 2005.
Although that language in and of itself would still be distinct from this, where there's a matter of.
That language was applied in situations where it was.
I understand.
Sentencing. So based on the precedent that has been established in the Court of Appeals and the Supreme Court, I'm bound to find that applied in this case in the motion to dismiss.
Okay. Well, we'll reset the defendant for determining this PTR, but I still take issue, and I get that there is a precedent, but.
Right, I understand.
Now we get to hear from the
The
defendant.
precedent was clear, and I get that they were doing that back sentencing in those cases. But the language still seemed, even with those back to that cases, to refer to law, which I would argue is still going to be distinct from the case where a court has said, we recognize the sentence exists in this prior case. We are creating a new sentence that cannot start until the other sentence is done.
Well, that's exactly what Rosa was. But I think that's exactly the circumstance in Rosa.
Yeah.
The defendant there was a specific period of time where the defendant was scheduled to have started probation. It wasn't even kind of ethereal. It was the defendant was to start on X date. 3 years prior to X date, defendant committed the offense. Defendant was not on probation or even serving any portion of the sentence at that point in time. And the Court of Appeals found that the application of Ashley and Ashwa and all of the one cases before that said, even notwithstanding that sentence was very explicitly not being served at the point in time, that the language of Ashley holds that from the time of sentencing, probation period starts doesn't end until it's scheduled to end. So that was very explicitly the holding in Rosa.
Yeah, I don't. The only distinction I would make there is that in that case, the sentence had not yet started at all, whereas in this case, he was actively serving a sentence. But
your argument in the sentence in the case that you were challenging had not yet started.
Yeah, and I understand.
Which is exactly the same situation as in Rosa.
Okay.
So when would you like to reset?
Your Honor, I would like to reset this relatively quickly. I don't believe those circumstances of PTR are that complex. I don't see a need to.
Are we resetting for an evidentiary hearing or resetting for?
I suppose that's a question for defense. You want an evidentiary hearing?
I'm just trying to figure out what's going on.
So the motion to dismiss has been denied.
I know, I've heard that.
Do you want to set an evidentiary hearing where they have to do
What is the evidentiary? So what is that? What do I have to see?
The state has to prove the bond. General knowledge to the evidence.
Right. Well, honestly, man, I'm just trying to get all this over with. You know, I got one case done. They dropped my felony case.
Do you want to come back to 28?
Whenever.
Okay. I appreciate you waiting patiently. I guess we saw this to come back.
What happened next court date? Like it's locked up, like
So
he didn't care one way or another. He's like, I just want to get this over with. This lawyer just passionately argued Supreme Court laws, and he's just like, look, I don't care. Just what happens next? How can we get this over with? Oh my gosh. No, the judge is right. Kelly, you called it. We see it all the time. Kelly said there's language in there when you get on probation. There's language already in there that covers this, and you're right, there is. So it happens all the time, and we see when people are getting sentences to consecutive probations, I mean, concurrent probations that they say, when they're going to get in trouble for both. So don't break the law. So the judge was right. The lawyer did a good job. He tried his hardest, but it just wasn't good enough. And now this guy can just get this over with like he wants. And Fozzie, I'm trying to remember double secret probation. Was it Animal House? I don't remember. I should remember Animal House. All right, guys, that's all I have for today. I hope the audio is good. I hope it was even. Me versus the courts. Not all the courts are the same audio, so I tried to mess with it. But every time I mess with the video, that just adds time, time. And I'm so short on time. But courts are going to open. Oh, I still have a bit of time. I can kick back and relax for a little bit. Courts aren't opening for a little bit yet. Yeah, I have time to go to McDonald's. But I'm not leaving. I'm too lazy for that. Oh, man. Thanks, Fozzie. Yes, I am a vampire as well. I don't know when the last time I've slept all night. It was a while ago. I think, kids train you not to sleep. They train you. Things they don't tell new mothers is you're never, ever, ever going to be able to sleep normally ever again. I know. I feel like I need to. Okay, I can extend this just real quick because what was it? A couple nights ago, I said I have a sleepy judge. That I was going to put a compilation together of this sleepy judge. And this is who she is. This is her court.
Mr. Struble is present for the prosecution. Mr. Kraus, you and I spoke at the end of January and you were applying for counsel. Did you complete your application? All right. You've probably heard me tell others that their computer system was down for most of this month. So with that, we can set over. Would you please call their office this week and check on the status? All right.
So she's the judge. I'm going to put together a video that I'm just going to upload. I do have to talk in it or YouTube will get mad. So I'll talk at the beginning. I'll talk at the end real low. I'll put my microphone down real low. Or I'll just type some words in. But this is a sleepy time. It's not to watch these court cases. It's just to use them to fall asleep. Oh, man. Fozzie, you're working right now. Poor thing. Yeah, go get a McGriddle. We'll all go get a McGriddle today. All right, guys. I will see you next time. I hope you have a good day. Bye. Or I hope you have a good tomorrow if you're in Australia.